So we were talking about the death penalty last week, and let me remind you, just to get you in the death penalty mindset, if you will, remind you what we were talking about last week, and then I want to finish up what I had to say about the death penalty. If you remember, first of all, the death penalty was around when the Constitution was drafted. It was a quite popular penalty at the time, but today the Supreme Court has put many limitations on implementation of the death penalty. So, for instance, as you see here at the bottom of the slide, the death penalty is reserved for homicide crimes, principally premeditated murder. It may not be imposed on juveniles, and it may not be imposed on people with retardation. The United States is the only Western country that still has the death penalty. We talked about why that might be, and to do that, we talked about the purposes of punishment, which I want to emphasize now because we're going to talk about the purposes of punishment over and over again in the next 5 weeks. The principal purposes of punishment are general deterrence, and then individual prevention, which includes things like rehabilitation and incapacitation, and then finally retribution. And as I said last week, the argument for the death penalty in general deterrence terms isn't all that strong. The research is very mixed, whether the death penalty actually does deter homicides. And same thing with respect to individual prevention. It's not a particularly strong argument for the death penalty in terms of individual prevention, given the alternative life without parole, which can incapacitate people and prevent them from hurting others. Probably the best argument for the death penalty is based on retribution, that certain people commit such horrible crimes, they deserve to be punished. They deserve to be punished and given the ultimate punishment, which is the death penalty. And then we talked about why Americans in particular might be so interested in the death penalty, and you see some of the reasons we talked about there last week. Then we got into the implementation of the death penalty, and I focused on Florida because that's the state with which I'm most familiar. But Florida is representative of other states with the death penalty. As I pointed out, Florida has a number of exonerees, and we started talking about why. That is, how does it happen that a person did not commit any crime whatsoever and nonetheless is convicted of capital murder and sentenced to death? Let's see if this works. Test? Test? Yes? It's working? Good. Okay. How does it happen that the sound system goes out every week? That's another important question. But it's working now. Okay. So that's what we were talking about, and we talked about a number of reasons why there might be exonerations, the possibility that people actually confess to something they didn't do because of police pressure or because of the kind of person they are, the fact that eyewitnesses sometimes get their identifications wrong, the fact that forensic labs, despite what you see on TV, can often be incompetent, the fact that we have an adversarial system, and sometimes that makes prosecutors believe they have to do anything and everything in order to win, and that can lead to inaccurate results. And the fact that defense attorneys aren't necessarily all that good, especially given what they're paid and how complicated these cases are. So that's what we ended last week with. And hopefully now you're back into the mindset of thinking about the death penalty. What I want to do now is talk about another phase of implementation. Because we focused on exonerees up until now. That is, people who in fact did not commit any crime and yet ended up on death row. Unfortunately, there are such people. Florida, again, has had 22 or 24 exonerees. There have been a number of other exonerees around the country. But most people charged with capital murder did kill someone, okay? That's obvious. Okay, the exonerees are a small subpopulation. Most people who are charged with capital murder did kill someone, but that doesn't mean they should get the death penalty, right? Not everyone who kills someone else should get the death penalty. For instance, if you accidentally kill someone, clearly you should not get the death penalty. Even if you intentionally kill someone, if you do it in the heat of passion, when you're provoked, the law recognizes that is usually not going to be a capital murder. That's a lesser form of homicide. So, as I said last week, what the Supreme Court has said is that the death penalty is reserved for the worst of the worst. If you're a retributivist, if you're a person who believes in retribution, another way of thinking about this is the most evil person, the most evil people should be executed. But not anyone else. The death penalty should be reserved for the small group of people who are the worst of the worst, the baddest of the baddest, the most evil. Okay? And what I want to talk about now is whether the death penalty system gets that right. Okay, assuming the person has committed a homicide, the next thing the legal system has to get correct, has to do accurately, is identify from among those who kill who was the worst of the worst, who was the most evil. And the research that's been done on the death penalty suggests that the legal system isn't real good at that either. Okay? It isn't real good at identifying, at separating out the worst from the average murder, if you will. Okay? Because that's what we're trying to do with the death penalty, right? Not every murderer deserves a death penalty. So average murderers shouldn't be executed. Maybe they should get life without parole or 50 years in prison, but they shouldn't be executed. We're trying to get the worst of the worst. Why might we not be very good at that? Well, here I want to talk about a separate series of findings that we produced in Florida, but I think is probably generally true around the country. One thing to consider is that in many states, including Tennessee, and certainly in Florida, judges are elected. Now, judicial elections might be a good thing for a number of different reasons. It certainly injects the democratic process into the judicial selection process. But it's also very controversial. For instance, in federal courts, judges are appointed. They're not elected. In a number of states, there are no judicial elections. Judges are appointed. And the people who don't like judicial elections believe that elections of judges inject too much democracy into the selection process, so that judges conceivably might abandon their neutral role, which is the role they're supposed to take, and become a little bit more partisan in the way they adjudicate cases. And there may be some evidence of that in the death penalty context. I'm not saying there is for sure, but there may be some evidence. Is it still not working? Okay, I'm going to keep on talking. I'm going to be totally oblivious to a person reaching into my pocket while I'm talking. So, for instance, in Florida, judicial elections, especially of Supreme Court justices, of Florida Supreme Court justices, are highly contested. A lot of money is spent on judicial campaigns. Oh, okay. All of a sudden, you know what I'm saying. Okay. So judicial elections in Florida are heavily contested, especially at the Supreme Court level. Lots and lots of money is being spent on judicial elections. It's not yet on a par with presidential campaigns, but for instance, you can have $1 million dropped on a judicial campaign in Florida, and one of the key issues in these campaigns is the death penalty. So for instance, one of the most famous political campaigns involved a woman named Rosemary Barquette, who was a great person, great justice, and she did win her election. She had to get 51% of the vote to get retained on the Florida Supreme Court. She got 51.2% of the vote. Extremely unusual. It's an extremely low retention rating. Most of the time, people get 80, 90, 95% retention vote. She got 51.2. Why was it so close? Because during the campaign, advertisements by the National Rifle Association, law enforcement groups, and related organizations repeatedly criticized her for opinions in capital cases, despite the fact that she voted for the court majority in favor of the death penalty 91% of the time. In other words, she was only in dissent 9% of the time, but that was too much for these groups that campaigned against her. Now, again, I'm not really giving an opinion of what I think about whether she was right or wrong in these cases. I'm just saying that the death penalty becomes a political hot potato and can affect judicial elections, and therefore maybe judges. Rosemary Barquette, in fact, did not write as many dissents in capital cases after this election. Now, was that because she really believed what she was doing, or was she affected by the elections? Hard to know. I asked her, she wouldn't tell me. There was also a study by two individuals, Steve Bright and Joe Keenan, a study of Florida death penalty cases, which found a statistically significant correlation between judicial overrides of life sentences by the jury and occurrence of elections. So in other words, what this study found is the closer the case was to a judicial election, the more likely it was for a judge to override a jury's finding of a life sentence and impose a death sentence instead. Okay? Which suggests, obviously, that elections were influencing judicial decision-making. And the further inference that a person who's against the death penalty might make is this is leading to inaccurate results. We're no longer going after the worst of the worst. We're trying to figure out who is being charged with capital murder closest to an election and basing the decision on that. So that's one possible concern. Another concern, jury confusion. I'm much more concerned about this than I am about judicial bias. I think judges on the whole are neutral, unbiased. There's a little bit of evidence to suggest that maybe the election process affects judges. I'm much more concerned, however, by the principal decision maker in a death penalty case, that is the jury, right? Because the jury not only decides whether someone's convicted of capital murder, it also decides once the person's been convicted of capital murder, whether that person's the worst of the worst, okay? Because it's jury sentencing in the death penalty context. The jury is the one that decides between the death penalty or life without parole or some other penalty. So, what do we know about juries? Well, it's not, let's see, how do I want to put it? It's sort of depressing. Let me put it that way. It's depressing. Remember last week I talked about the fact that what happens in a capital jury sentencing proceeding is that the prosecution proves aggravating circumstances. What's an aggravating circumstance? The individual has a number of prior crimes. That would be an aggravator. That would tend to make the person look like the worst of the worst. Or the person killed a whole lot of people at the time of the killing. Killed 3 people or 5 people instead of 1 person. Or the person killed in order to make sure the person wasn't a witness to a rape or a robbery. So in other words, you got 2 crimes. You got the killing plus an underlying offense. So those would be aggravating circumstances. According to the Supreme Court, the prosecutor has to show beyond a reasonable doubt at least one of those aggravating circumstances. Okay, so that's the law. One aggravating circumstance beyond a reasonable doubt, which is a very high-level standard of proof. Then there are mitigating circumstances. And of course, these are the circumstances, these are the factors that the defense presents. What's a typical mitigating factor? Mental disability. Mental disability short of insanity, but nonetheless some kind of impairment. Or, as I said last week, also youth is a mitigating factor. Also, if the person was a follower as opposed to a leader. If there were multiple defendants, if the defendant was someone who was just sort of following along with the gang, not the ringleader, that might be a mitigating circumstance. The defense is allowed to present virtually any mitigating circumstance, anything that might create sympathy for the defendant. Right? So you pull out all the stops as a defense attorney. My client was abused as a kid. My client has a mental disability. My client's mother hated him. Whatever, okay? Anything that might create sympathy is a possible mitigating circumstance. And also importantly, the defense does not have to show these mitigators beyond a reasonable doubt. The prosecution has to show the aggravating circumstance beyond reasonable doubt. The defense just has to show some kind of evidence of the mitigator. So that's the law, okay, in a nutshell. The jury looks at the aggravators, looks at the mitigators, mushes them all together, and decides whether the person should get the death penalty or life without parole. It's not a numerical thing. Let's say the prosecutor proves 1 aggravator and the defense shows 3 mitigators. That doesn't mean the defense wins, okay? It's a totality kind of analysis. The jury just puts it all together and figures out whether the person should get the death sentence or life without parole. And by the same token, even if the prosecutor shows 3 aggravators and the defense only shows 1 mitigator, it's still possible for the defense to succeed at getting life without parole or something less. Okay, so it's not a numerical kind of exercise. The jury is looking at everything under the totality of the circumstances and figuring out whether someone should get the death penalty. Okay, so that's the law. It's not that hard to understand, right? It's pretty straightforward, but juries don't get it. Yeah, okay, I'm going to get to that. That's a good question. Let me get to that in just a second. But first of all, there's a lot of research on this, asking people who have actually served on capital jurors. So they've gone through the process. They've heard the instructions, okay? And some of them don't understand what the word aggravator means, don't understand what the word mitigator means. In other words, they get them confused, which is not a real good thing in a capital sentencing proceeding, okay? A lot of them, and in fact, I'll give you percentages instead of saying a lot of them. According to a study by the Capital Jury Sentencing Project, which was the study I referred to, which asked people who had actually been in capital jury cases. These were not just pulling people off the street and asking them about death penalty law. These are people who had been on death penalty juries within the last year. 49% of the participants did not understand that they could consider any evidence of mitigation. Okay, they thought they could only consider certain factors of mitigation. And 48.7% were under the misimpression that they needed to find mitigating evidence beyond a reasonable doubt. That's wrong. Remember, I just described to you, the beyond reasonable doubt standard does not apply to mitigators. The same study also found that over 36% of the jurors interviewed believed incorrectly that they were required to sentence the defendant to death if they found the defendant's conduct to be vile or depraved. That is an aggravating circumstance. Okay? If you commit the crime in a particularly vile or heinous manner, that's an aggravator. But what these jurors thought, what 36% of the jurors who were interviewed thought, was if they did consider the murder to be vile and heinous, they had to impose the death penalty. They couldn't consider mitigators. That is dead wrong. That is totally inaccurate in terms of what the jury is supposed to be doing. And 25% believe that if they found the defendant to be dangerous, they were required to impose the death penalty. Required, without any consideration of mitigators. These are people who actually sat on capital juries, capital sentencing juries. That's scary. Now, if I were arguing the other side, I would say, yeah, but these are just percentages of jurors. There were other jurors there who presumably understood the law and may have corrected these misimpressions. And that is possible. And yet, these are people
who sat through a capital sentencing proceeding and still apparently are confused. So maybe their confusion was not corrected, or they understood what was going on at the time of trial and they've gotten confused in the meantime. That's not clear from this study, but it's still a little bit disturbing to see these high percentages connected with jury confusion. So that might be another possible reason we don't necessarily identify the worst of the worst. Juries are a little bit confused about what they should be doing. And by the way, there's research on jury confusion outside the capital context too. Juries get confused about lots of things. And it's not because they're dumb, okay? Legal instructions can be very confusing. They can be very difficult to understand. And in some states, you're not allowed to take the jury instructions back to the jury room. So you have to remember what the judge tells you, okay? And the fear is, some people say, oh, why is that? Well, the fear is the jury will go back to the jury room with those instructions and try to play lawyer. Okay, they'll go over it word by word and get all bollocksed up. Now, whether that's the correct assumption or not, I don't know. But that's the rationale for not allowing, in some states, not allowing jurors to have the instructions back in the jury room. Yes? Okay, yes, it is possible for jurors to go back into the courtroom and say, Judge, we're confused about this. Can you clear it up? That can happen and it does happen. But it doesn't always happen. And this research suggests that maybe it didn't happen in some cases. But it is possible, okay? And in fact, you can also, in some states, you can ask a question in writing and send it to the judge and send it back. And hopefully that's what jurors would do if they're all confused or if they can't remember what the instructions said. It's also the case that states are slowly but surely making their instructions more understandable. The old-time instructions used to take the language right from the statute. And any of you have read a statute, well, if you want to go to sleep at night, just get a statute, okay, and read it. It'll put you to sleep immediately because you won't know what's going on, probably, unless you've been legally trained. That's where the instructions came from years and years ago. Now we're starting to do instructions in plain English. And so the problem is being corrected, but still, even with the plain English instructions, we're having problems. Now, going to your question about unanimity, it's not required that juries be unanimous at the sentencing proceeding. They do have to be unanimous at trial. Okay, if it's a 12-person jury, which it usually is in a capital case, all 12 people have to agree that the person is guilty of capital murder. But at sentencing, it is permissible to have a 7-5 verdict in favor of the death penalty. And in fact, that's what happens in Florida. Now, if a jury comes back with a 7-5 verdict in favor of the death penalty, a judge can override that. And in Florida, often judges do override that kind of verdict. Why? Because it's so close. And the judge say, hey, 7-5, I'm going to impose life in this case. But if it's a 8-4 verdict, a 9-3, usually judges do not override. That verdict stands. Is that constitutional? We don't know yet. That particular approach to jury capital sentencing has not been directly confronted by the Supreme Court. However, the Supreme Court has said that a 9-3 verdict at trial is constitutional. So if a 9-3 verdict at trial is constitutional, presumably a 9-3 verdict at a capital sentencing proceeding would be constitutional. The only difference being the Supreme Court case involving the trial situation was not a capital case. It was not a death penalty case. And the Supreme Court might say, hey, death penalty is different. We're going to require unanimity when it's a death penalty. But if I were the prosecutor, I have a lot of case law on my side arguing for the proposition that a 9-3 verdict or even a 7-5 verdict is constitutional. If I were the defense attorney, I'd say, wait a minute. The prosecution has to show its aggravator beyond a reasonable doubt. How can you say there's no reasonable doubt when 5 people on the jury are saying they don't think the death penalty deserved in this case? But, okay, enough said about that. It's a good question, though, okay? Another reason why we might not get the worst of the worst in capital sentencing proceedings is the complicated issue of mental disability. Now, in a little while, we're going to be talking about the insanity defense. And we'll talk about a lot of nuances having to do with insanity. But right now, I just want to focus on one thing. And that is, as I said before, that mental disability is one of the key mitigators, right? That's one of the key pieces of evidence that a defense attorney will present. My client was abused as a kid. My client has a psychotic diagnosis or some other kind of diagnosis. Granted, he wasn't insane at the time of the offense, but had a significant impairment. The problem is that evidence often backfires. In fact, defense attorneys at their capital, when they meet together to talk about capital cases, often have entire panels on this topic. The defense attorney feels like he or she's between a rock and a hard place because you want to present the mental disability evidence as a mitigator, but you're worried the jury will use it for precisely the opposite purpose. The jury will say, this isn't a mitigator, this is an aggravator. Now why? And let me tell you a study that shows what I just told you before I answer the why question. You probably already answered it in your head, but before I answer the why question explicitly, there's one study by a guy named David Baldus that looked at over 300 factors that might influence capital sentencing jurors. He was trying to figure out, why do juries sentence people to death? What are the factors that most influence juries? And one factor, clearly, is number of prior offenses. In fact, that was the most significant aggravating factor. That was the factor that most significantly influenced juries that imposed the death penalty. Makes sense, right? The guy's committed a whole bunch of crimes in the past. Yeah, maybe that guy is one of the worst of the worst. What was factor number 2? Believe it or not, raising an insanity defense at trial. If a person raised an insanity defense at trial and lost, obviously if he won, he'd be acquitted by reason of insanity, but if he lost, then he's convicted of capital murder, then you go to the capital sentencing proceeding. A person who raises the insanity defense and loses is highly likely to get the death penalty. Now what's going on there? Presumably there's some evidence of mental impairment, right? He raised the insanity defense, unless his lawyer is just making it up totally. There's some evidence of mental impairment because he presented an insanity defense at trial, and yet it's the second most influential factor in terms of death sentences. What's going on? Probably what's going on is that jurors equate mental disability with dangerousness. If a person is mentally disabled, they're dangerous. And we know from other research that regardless of what their instructions are, juries focus on dangerousness above anything else when they're deciding whether someone's the worst of the worst. That's why prior crimes is so important, right? If a person's committed a whole bunch of crimes in the past, I think the jury's probably thinking, well, that person probably will keep on committing crimes unless we kill him. So we need to execute him. Well, apparently mental disability also is evidence of dangerousness, just like prior crimes are. Why? Because there's this lay perception that if you're mentally ill, you're dangerous. Now, that's a wrong perception. All the research shows that mental illness is not a major contributing factor to dangerousness. You may think that is the case, but in fact it's not. Research shows over and over again that even serious mental illness, like psychosis, is not a major contributor to dangerousness. In other words, people with serious mental illness are no more likely to commit a violent act than people who do not have a serious mental illness. Now, what are some predisposing factors of violence? Substance abuse. That's a clearly predisposing factor. If you drink or use drugs, you are more likely to commit violent crime. And a lot of people with serious mental illness do use drugs or drink. But when you separate out those factors, it turns out that mental illness by itself is not a major predisposing factor to violence, unlike substance abuse. But jurors think the opposite. Well, not the opposite, but they think mental illness is a predisposing factor. At least that's the theory upon which these researchers are operating. And so the bottom line is, if you're a defense attorney and you present evidence of serious mental illness, thinking it will mitigate, it might have just the opposite effect. And that's why I refer to it as the double-edged nature of mental disability. Okay? It's a real difficult problem. One way to try to solve it is to emphasize to the jury mental disability may only be used to mitigate. But whether they pay attention to that instruction, we don't know. Yeah, certainly you could argue that if a defense attorney, that even if you think my client is dangerous because of the mental disability, you always have that life without parole option. As I said last week, when life without parole is given as an option to the death penalty in these surveys, the support for the death penalty does drop. Once again, emphasizing that dangerousness does seem to be a prominent factor in people's thinking about the death penalty. So yeah, that's a good argument. But nonetheless, it appears that juries are thinking, okay, I have a dangerous person on my hands. What's the best way to deal with him? Kill him or life without parole? Life without parole is pretty good, but killing him is really good. Right? Life without parole, what can happen while a person's in prison? I mentioned this last week. You can kill a guard, kill another prisoner, maybe escape. Right? There is always that possibility. So I agree with you. I mean, if I'm a defense attorney, I definitely argue life without parole can incapacitate my client. But I can still see juries saying, you're not convincing me. Death penalty is a better option. Okay, another possible difficulty here in terms of separating out the worst of the worst from others is what I already talked about last week. Not only are defense counsel often not very good at trial, they continue to not be good at sentencing. Okay? In other words, they have real problems with providing competent representation in sentencing. Now, to be fair to them, one reason for that is what we just got through talking about. What do you do with the client whose only mitigating circumstance is mental impairment? It can be a very tough call because of the double-edged sword problem that I just got through talking about. But the fact remains, in case after case after case, and I've read a lot of them, defense attorneys don't do anything at sentencing worth speaking of. Okay? Now, they might try to explain it away by saying, oh, I was worried about the double-edged sword problem. But these are cases where there's clear evidence of genetic problems, of neurological problems, of other kinds of psychiatric problems, of a long history of abuse, other kinds of sympathy-inducing kinds of factors. And the defense attorney barely weighs at that stuff. May not have any experts or only has one expert, doesn't do a lot of work on this stuff. The single most frequent cause of reversals of death sentences in the state of Florida, and probably around the country, is ineffective assistance of counsel. The Florida Supreme Court does not overturn too many death sentences, especially after Rosemary Barquette's campaign that I talked about earlier. There are not too many reversals of death sentences. But if they do reverse, by far the single most important reason is ineffective assistance of counsel. The Supreme Court of the United States, which is not a huge fan of overturning death sentences, nonetheless, in the last 2 years, has overturned 3 death sentences because attorneys were so bad at the sentencing proceeding that even the Supreme Court of the United States said, we're not going to accept this death sentence. Okay, so this is a real problem. And again, it goes back to some things I talked about last week. Defense attorneys maybe aren't paid very much. They've got a lot of other cases they got to worry about, or bottom line, they don't know what they're doing. Now, there are lots of courses for defense attorneys to teach them what they should do, but not all defense attorneys can get to those courses. And so there's an incompetence problem. Yes? Okay, good point. So the question was, in case you didn't hear it, what would a defense attorney present at a sentencing hearing that he or she would not have already presented at trial? In terms of mental disability, it might be very similar evidence. Okay? If you raise the insanity defense at trial, you're probably going to use an expert witness, talk about psychiatric symptoms and so on. As a defense attorney, you probably will introduce the same kind, maybe even the same expert, same kind of testimony at sentencing. You might expand on it, though, because the insanity defense, as we'll talk about in a little while, is very narrow. You have to be really ill in order to be found insane. In Tennessee, you basically have to be totally crazy in order to be found insane. I can't think of a better way to describe it. In Tennessee, you have to be very, 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 10 more varies crazy before you can be found insane. Whereas at sentencing, you don't have to be that crazy, to use a lay term, right? So you might expand on the definition of psychiatric symptomatology at sentencing. There are other things that generally aren't going to be admissible at trial, but would be admissible at sentencing. For instance, you can't make a big deal out of youth at trial, whereas you can have an expert on the stand to talk about how juveniles' brains are different than adult brains. You can do that at sentencing. And by the way, we're going to talk a lot about that particular point the last session of this course. We're going to talk a lot about juveniles the last session of this course. And there are other various aspects of character that the defense could introduce at trial, but probably doesn't want to, because once the defense attorney raises the issue of character, in other words, tries to show his or her client is a good character, what is the prosecution allowed to do? Bring on all sorts of evidence of bad character. And you, as a defense attorney, you don't want that happening. If you have any evidence of bad character in your client's past, you don't open the door by introducing evidence of good character. So that might be reserved for sentencing also. Okay? Okay. Another way people can avoid the death penalty, if they're not the worst of the worst, is the governor granting clemency. You've all heard of this, right? The governor, what was that? Moved to Mississippi, yeah, and get pardoned there right before Haley Barbour, his next term. Clemency does happen. There are pardons in Tennessee as well as elsewhere, but in death penalty cases, they're extremely infrequent. And again, it's because the death penalty has become such a political hot potato. Then I'm just going to give you some evidence from Florida. What we found in Florida is that basically clemency in death penalty cases has disappeared. The last time a governor granted clemency to a person sentenced to death was in 1983. 1983, almost 30 years ago. And that's about the time the death penalty became a very serious political hot potato. During political campaigns beginning in the 1980s, Florida governors often made the signing of death warrants a part of their campaign strategy. In other words, they would boast about how many death warrants they signed. So, for instance, one candidate boasted he had signed 90 death warrants, 90 death warrants in his 4 years of office. And as the commentator said, nothing sells on the campaign trail like promises to speed up the death penalty. So, again, I'm not giving an opinion about whether this is good or bad. I'm just saying that the death penalty has become such a political item that governors are afraid to touch it. And so they are not granting clemency. Clemency grants throughout the country have gone down precipitously in the last 20 or 30 years. The final thing I want to talk about in terms of why the worst of the worst might not be identified in the death penalty process is racism. It's important to talk about racism in the death penalty context and with respect to the criminal justice system generally. It does exist. It's perhaps not as bad as it was 30 years ago, but there's no doubt it still affects the process. In the death penalty context, the particular concern 30 years ago was that many more African Americans were being sentenced to death than whites. That has diminished significantly. There's still a slight disproportionate impact on African Americans as opposed to whites in terms of race of the defendant. That is, more African Americans are being sentenced to death than whites, but not by significantly greater margin given their representation in the population of those who commit murder. But where there is a significant disproportionate effect is in race of the victim. Now, what does that mean? It means a person who kills a white person is much more likely to get the death penalty than a person who kills a black person. Okay, and that's a form of racism, people have argued. Okay, why do we value a white life more than a black life? We're executing people, much more likely to execute people who kill a white person than kill a black person. And this is a robust scientific finding. Over and over again, this has been the finding of studies. David Baldus, the guy I mentioned before, he did a study of Florida and a couple of other states, and he said, we estimate that 1/4 to 1/3 of death sentence defendants with white victims would have avoided the death penalty if their victims had been black. Okay, 1/4 to 1/3. And this is this category I'm talking about. These people did kill someone. Okay, these are not innocent people. They did kill someone, but they're on death row because they killed a white person as opposed to a black person. That's at least what Baldus is asserting in this study through fairly sophisticated statistical analysis. The Florida Supreme Court itself, which is not known for its liberal knee-jerkism, said the application of the death penalty in Florida is not colorblind, inasmuch as a criminal defendant in a capital case is, other things being equal, 3.4 times more likely to receive the death penalty if he killed a white victim. That's the Florida Supreme Court speaking. So that's interesting, and conceivably should call into some doubt the whole death penalty process, right, if we're worried about racism. And in fact, it was argued in the case of McCleskey versus Kemp. The Baldus study, as well as other research, was presented to the United States Supreme Court in a case where the defendant had killed a white person and said, my trial was unfair. This research shows it was unfair. I was probably charged because I killed a white person, and I was sentenced to death because I killed a white person. And that's unfair. The Supreme Court didn't buy it. The Supreme Court affirmed the death sentence, basically for two reasons. One is these statistics are about a whole bunch of people. It doesn't necessarily mean anything about your case, Mr. McCleskey, right? Your trial could have been perfectly fair, despite the fact you killed a white person. And that makes some sense, right? It's conceivable that McCleskey really was the worst of the worst, okay? And he shouldn't be able to avoid the death sentence just because research shows that, in general, people who kill a white victim are more likely to get the death penalty in an unfair way than people who kill a black person. So that was reason number one. Reason number two, and in many ways is more interesting, is one of the times when the Supreme Court got really candid. I don't know, maybe the person who wrote the majority opinion, somebody put something in his coffee, because he said, the other reason we're not reversing the sentences, if we did, we'd call into question the entire criminal justice system. Now that's very candid, okay? If we end up saying Mr. McCleskey wins, we're saying racism infects the whole thing, and we don't want to say that. So we're not going to. Now what's particularly ironic, the reason I have Justice Powell's name up here, this is a 5-4 decision. McCleskey just barely lost. A 5-4 decision. Justice Powell was in the majority. He was one of the 5. He retired from the court, and his biographer, John Jeffries, interviewed him about the McCleskey case. What did Powell say? I made a mistake. I made a mistake in McCleskey. I should have voted the other way. I've come to see the error of my ways. Well, a little bit too late, Justice Powell. So that's very interesting. And again, you can agree or disagree with McCleskey versus Kemp, but it's very interesting how it all played out at the Supreme Court level and in terms of what Justice Powell has said. I'm sure that if this case got to the Supreme Court again, which it probably wouldn't because it's been decided, but if this kind of case got up again, the Supreme Court would affirm McCleskey versus Kemp, given the current lineup of the Supreme Court. And maybe it should, but it's still important to recognize that racism influences and permeates the criminal justice system in various ways. And so that's something to keep in mind as we talk about the criminal justice system for the next several sessions. So, last thing I want to talk about with respect to the death penalty, fairly quickly, is the economics of the death penalty. Because we've talked a lot about possible problems with the death penalty, that innocent people are sometimes sentenced to death, and that even people who kill people maybe shouldn't get the death penalty, but rather it's something less, that they may not be the worst of the worst. That some people who are sentenced to death may not be the worst of the worst. And those are some of the reasons why states have started to move away from the death penalty. Remember, last week I talked about the fact that 7 states have abolished the death penalty since it was reinstated back in 1976. And of the 33 states that are left, several of them are seriously contemplating getting rid of the death penalty. Not mostly states outside the South, but nonetheless, a lot of states are reconsidering the death penalty. One reason states are reconsidering the death penalty, though, has nothing to do with what we've talked about up until now. It has only to do with this. The fact that death penalty is incredibly expensive. And that can be a reason, independent of anything else we've talked about, for why the death penalty may slowly disappear. First of all, just talking in terms of judicial resources. Under Supreme Court law, every time a death sentence is imposed, there's an automatic right of appeal to the state Supreme Court. Automatically. And that's for fairness reasons, right? We want to make sure that we double check the trial court opinion with respect to sentencing. So automatic appeal. What that has done in the state of Florida is it's made death penalty cases 50% of the docket. 50% of the docket. 1 out of every 2 cases the Florida Supreme Court considers as a death penalty case. It doesn't have time for other cases because of the death penalty. So that's one form of economic cost. More directly, and this is sometimes hard for people to believe, but in the state of Florida, according to the research, death sentence cost about $2.5 million more than a life sentence amounting to about 40 years. Now, why is that? I mean, you kill the guy, right? So that should be pretty cheap. I mean, other than the electricity you need to kill him, or the lethal injection substances that you use to inject the individual, and the short amount of prison time that the person spends on death row, that should be less costly than life without parole, a 40-year sentence. Turns out that's not true. Why? First of all, the average time between a death sentence and execution is 8 to 12 years because of the appeals process. Now, if we streamline the appeals process, that would cut down on costs considerably. But right now, the appeals process is 8 to 12 years. Okay? Additionally, the trial itself is incredibly expensive. I happened to be in Gainesville, Florida, the University of Florida, when a man named Danny Rowling was charged with capital murder. And he, by the way, if you're going to kill someone, he's the one to kill. Okay? He killed 5 people. He beheaded 4 of them. So he killed 5 people, extremely vile, heinous kind of murder. Basically a psychopath, not a very attractive person, not much going for him. Okay, so arguably he deserved the death penalty, if anyone did. Cost the county of Alachua, which is the county that Gainesville is in, $3.5 million just to get through the trial and sentencing. Now, why is that? Because the state's paying for the prosecutor, obviously, and all the prosecutor's resources. It's also paying for the defense attorney because Danny Rowling was represented by a public defender. Public defender gets a state salary. Now, the salary isn't all that much, but the expenses associated with getting the mitigating evidence, and by the way, this was a good representation. Danny Rowling got a very good defense, but it cost a lot of money. Alachua County was almost bankrupt at the end of this trial. And then you add on, it took 9 years, I think, to execute him. So you have all that time in prison. You add all that up, and this is the statistic you get. Yeah, did you have a question? Okay, okay. Now, if you're in California, it's even worse. Of course, California does everything different. $250 million to kill someone in California. Now, why? I don't know. And to tell you the truth, I'm just reporting something I've read. I have not investigated these statistics, so I cannot vouch for this. This seems inflated to me. But that's the number that you get if you look at the Death Penalty Information Center. Well, yeah. Do you think if money deters? Yeah. Maybe even only 1 million would be enough to deter someone from committing murder. The point being, this is really expensive. This may be an inflated figure, but it is expensive. And so, for instance, this task force that I mentioned last week, where I chaired a task force looking at the Florida death penalty system. I had a couple of prosecutors on that task force, as well as judges and so on. And one of the prosecutors, again being very candid, said, look, I like the death penalty as a philosophical matter. I think there are people that are extremely evil. They ought to be executed. But I'm not in favor of the death penalty anymore because it's sucking the rest of the resources out of the system. Okay, it's draining my office dry. I have to appoint my best prosecutors to death penalty cases. I have to use all of my expert testimony resources and my investigative resources for death penalty cases. It's making it very difficult to do justice in other cases, in non-capital cases. So he said, I'm against the death penalty for economic reasons, not for philosophical reasons, but for economic reasons. And this is why some people are predicting that the death penalty is slowly going to disappear, except for perhaps in the South. It's slowly but surely, it's going to disappear either for the reasons I stated earlier, that innocent people are being sentenced to death, we're just not able to identify the worst of the worst, or for the economic reasons that I'm talking about. Yes? Well, this comparison in bullet number 2 is it tells you the answer to that. Okay? Now, in absolute figures, I don't know. It's going to vary from case to case. But an LL.M case is $2.5 million cheaper than an execution. That's what that second bullet's about. Okay? It's expensive, but not as expensive, at least given the current death penalty system. Now, I've been on some radio shows talking about the death penalty, and then they have call-ins, and almost all the callers are very pro-death penalty, as opposed to anti. And I try to be pretty neutral in my presentation, but they want to convince me the death penalty is a good idea. And very often what you'll hear from these people is, look, we ought to have the death penalty for everybody who commits a crime down to burglary, and after they're sentenced to death, we ought to take them out of the public square and kill them. And that'll be a lot cheaper. And they're right about that. If that's the death penalty system we had, this would not be correct. This second bullet would not be right. But for better or for worse, and I think it's probably for better, our system has decided that we need to be very careful before we execute someone. So we need to have this appellate process, which granted is expensive. But it's the price you pay for making sure you have due process and accurate results. And even with that process, as I've said, we don't always get accurate results. Okay? Right. Yeah, you do. It's just $2.5 million cheaper, but you're right. Right. A lot, but nothing compared to the death penalty. That's what the second bullet's about. But I can't tell you the exact figures. And I'm sure in California it'd be more expensive. I don't know. Maybe they give them, 2 desserts instead of 1 at every meal. I don't know. But in any event, it's more expensive in California. Okay. Oh. Yeah. Okay. The question is, why is the appeal process so long? Very good question, right? Certainly, we should be able to get this over with more quickly. Well, first of all, there's an automatic appeal to the state Supreme Court. That's required constitutionally. And it can take up to a year and even 2 years to get it up to the Florida Supreme Court. Why? Look at the first bullet here. Their docket is 50% death penalty cases. They got a backlog. Right? It takes if you want to be fair, you want to do justice, you need to look at these cases very quickly. The records in these cases, I can't do it justice here with my arms. Okay, it's a fish story. I mean, the record is bigger than this. With all of the evidence you got, the transcripts of the trial, the transcripts of the sentencing proceeding, the expert depositions, et cetera, et cetera, et cetera. Justices in the Florida Supreme Court feel that maybe not every one of them has to go through all of that, but one of them at least has to go through all of it. They have to make sure they're doing justice to the case. That takes a while. Then after that, usually, there's a writ of habeas corpus filed, first in the state courts, then in federal courts. So each of those stages could take another year or 2 years. The federal courts are notoriously slow because they have an incredible backlog. They're not just dealing with death penalty cases, they're dealing with Social Security cases, they're dealing with garden variety criminal cases, et cetera, et cetera, et cetera. So it takes a while to get your case heard in federal court. And there are 3 levels of federal court. There's the federal district court. That's where you file your writ habeas corpus. Then there's the Circuit Court of Appeal. We're in the 6th Circuit here in Tennessee, 6th Circuit Court of Appeal. And then there's the United States Supreme Court. Now, the Supreme Court usually rejects it. It doesn't hear it, but it takes a while for the Supreme Court to reject it. You add all that together, it can take 8 years, pretty easily. And the average is over 8 years. Yes? Mm-hmm. Yeah, so the comment was, why not pour money into the courts and hopefully expedite these appeals and other appeals, and that way avoid some of the prison costs associated and other post-conviction costs associated with death penalty. Yeah, that's in fact, the 11th Circuit, there are 13 circuits, courts of appeal. Those are the intermediate courts of appeal just below the United States Supreme Court. The 11th Circuit, which oversees Florida, made a proposal for expediting death penalty cases. Unfortunately, that's the way they advertised it. It didn't go over too well. Let's speed up executions, was the way it was sort of billed in the newspapers. And even people who were pro-death penalty weren't necessarily in favor of that particular way of putting it. But to answer your question more directly, that was a serious enterprise. And it's conceivable that could improve the pace at which death penalty cases are considered, but probably would still take 5-6 years. It would cut costs, but not appreciably. And as you may know, generally speaking, appropriations for judiciary are being reduced now, not increased. That's right. That's right. This slide has nothing to do with morality or philosophy. It has only to do with economics. But this seems to be influencing lots of people. In contrast to the slides I showed before, which are not, they are influencing people, but not as much as this slide. Yeah. Sounds like we have some economists in the room, okay? Yeah, you can expand cost-benefit analysis infinitely, right? You can add things to the cost side, you can add things to the benefit side. That's what we do as academics often. But I think you're right. That can be a real problem, yeah.
Why do you think people in the South love death?
Well, that's a loaded question. Why do I think people in the South love the death penalty so much? I actually tried to address that last week when I talked about what I called American exceptionalism. There's possibly the effects of racism, which may be a little bit stronger in the South than elsewhere. There's this idea that America's a particularly individualistic culture, so they are more willing to ascribe free will to an individual who kills someone else, and that makes them more punitive than, let's say, Europeans, who are more willing to think of people as who kill or otherwise as more the result of their entire context as opposed to an individual choice that deserves punishment. There are other reasons I gave. I don't know if those adequately explain it. People have tried to equate the death penalty with the lynchings that took place in the South back in the 19th and early 20th centuries, and there were a lot of them. Usually, not always in the South, by the way, but most of them were in the South, usually of African Americans. And people have made that association, that the South was used to killing people, so it hasn't gotten out of the habit yet, to put it colloquially. But I don't know. I don't know the answer to your question. As an empirical matter, it's clear that most executions take place in the South. The more southern states have the death penalty, and that its resistance to it is less in the South than anywhere else in the country. So, yeah. Mm-hmm.
That's a curious question. If I were an evil girl or a black person, and I'd like to kill people, what would be the best state to avoid?
Well, the question is, what states are the best states to kill someone in if you want to avoid the death penalty? There's 17 of them. As I said last week, all of the new states, New York, New Jersey, New Mexico, go to any one of those. The Northeast, not surprisingly, virtually no death penalty states there. California's not a death penalty state, and there are a lot of people who might want to kill there in that state. So, you know, yeah. the question is, was Ted Bundy, did he move to Florida in order to be what? I've never heard that. I mean, Ted Bundy was a very clever person. I'm not sure he wanted it to die. There is some innuendo he did, but my guess is actually he didn't want to die. He did a very good job representing himself. You may remember Ted Bundy, right? Serial killer in Florida. In fact, Donnie Rowling, the person I mentioned earlier who decapitated four people, he saw Ted Bundy as a role model. He actually Ted Bundy killed his victims in Tallahassee. Danny Rowling went to Tallahassee first, thinking he would do exactly what Ted Bundy did, but bought a knife at a convenience store in Tallahassee, realized it might be traceable to him, so he decided to go to the next town down the pike, which unfortunately was Gainesville. Next town with the university, and that happened to be Gainesville, and that's why he committed his murders there. So Ted Bundy did a good job representing himself, and it suggests that he was trying to avoid the death penalty, though he later did, this was very interesting, he later claimed his death sentence should be reversed. Why? Ineffective assistance of counsel. That's how clever he is, okay? Okay, so I want to move on now to the insanity defense. After every topic, I'm going to give you a reference if you want it. This is a reference that summarizes all the Florida data that I've been talking to you about, if you want to look at it. But I want to move now on to our next topic, and we're not going to finish with this topic today, but that's okay, because in fact, this topic, which is the insanity defense, segues very nicely into the third topic, which is preventive detention. So I'm actually intentionally not going to finish with the insanity defense today. We'll continue to talk about it next week. But I do want to start talking about the insanity. Do we really only have 15 minutes left? Okay. Well, we'll just get a brief start to the insanity defense. But that's okay, like I said. And by the way, one reason we spent so much time on the death penalty is not just because it's an interesting topic in and of itself, but just to emphasize something I said last week. The topic is really about the entire criminal justice system. I think McCleskey versus Kemp brings that home very clearly. And the Supreme Court said it itself, that we'd have to seriously question the entire criminal justice system if we bought Mr. McCleskey's argument. So everything I'm talking about, the interrogation situation, eyewitness identifications, incompetent labs, poor defense work, adversarial prosecutors, it's true in capital cases, it's most prominent there, but we have those same kind of problems throughout the entire criminal justice system. So it's worth spending a whole lot of time on the death penalty just for that reason. Okay, the insanity defense, very controversial topic. That's why I listed it as one of the hot topics. Every time there's a famous insanity case, whether it's the John Hinckley case, the man who tried to kill President Reagan, or Andrea Yates, the woman who drowned her 5 children, there's a lot of press coverage, and I would guess a lot of conversation around the dinner table. People talk about these cases because they're fascinating, and they really get us into what it means to be human, what it means to be held accountable for your actions. I know that some of my friends who are not law professors, they had conversations about the Andrea Yates case in terms of, okay, when do we hold a person responsible for their actions? Was Andrea Yates responsible in a legal way for drowning her kids? Clearly, she was the physical agent who killed her kids. She was the one who put them in the bathtub, but she be held responsible for them. The reason it's so controversial, the reason the insanity defense is so controversial, is under this defense, if you do the crime, you don't do the time, right? You don't go to prison. Now, you might end up in a mental hospital, sometimes for a very long time, but you don't go to prison. And so it is very controversial all over the country, not just in the South, all over the country. The verdict is called not guilty by reason of insanity. But what it's really saying is, you're not guilty even though you did it. Why? Because you were seriously mentally ill at the time of the offense. So a whole lot has been written about the insanity defense. And I'm going to try to give you a sense of what that literature says in the brief time we got here today and the first part of next week. Now, one thing to be clear on is the insanity defense has been with us for a very long time in some shape or form. A lot of people tend to think the insanity defense is the invention of psychiatrists and psychologists who didn't come along until the end of the 19th century and started claiming that people were mentally ill and therefore should be excused. The Greeks and the Romans were excusing people because of mental disability. And there were kings pardoning criminals on the basis of mental disability in medieval times. Even in medieval times, people were being excused by reason of mental disability. Now, granted, you had to be very mentally ill in order to be excused. For instance, in medieval times, the test was described as the wild beast test. Okay, you had to be so out of touch with reality, so out of control that you were like a wild beast. But if you were like a wild beast, then the king pardoned you, and you were not executed. Now, you might be put in a very horrible place, but nonetheless, you weren't executed. And so even in medieval times, we had this defense. Today, we don't have the wild beast test anymore, though you could argue in Tennessee and other states that's pretty much what you have to be in order to be excused, and I'll back that up with what I say later. But we have legal instructions that are more restrictive and talk in a more precise way about when a person should be excused. For instance, did the person know right from wrong at the time of the offense? Or did the person have an irresistible impulse at the time of the offense? So we'll talk more about that later, but I want to talk about some famous cases first. How many have heard of this case, just out of curiosity, the Daniel McNaughton case? This one is not so famous. This is the case that really got modern insanity law started, because the most famous insanity test is the McNaughton test. It's named after this guy. One of the most interesting controversies over the Daniel McNaughton case was, how do you spell McNaughton? There was actually an article. Academics will write an article about anything. And one of the articles about Daniel McNaughton is the 21 different ways that McNaughton can be spelled. It's a Scottish name, and the Scots apparently like to mess around with people. So there are lots of different ways of spelling this name. But this is the accepted spelling. What happened in the McNaughton case? This is a person who probably had paranoid schizophrenia. And by the way, schizophrenia is not split personality. Okay, I'm going to use the word schizophrenia a lot today and next week. A lot of people use the word schizophrenic to refer to a person who talks out of both sides of their mouths or has two different opinions about the same thing or has a split personality. That's not schizophrenia. What split personality is diagnostically is either multiple personality disorder or dissociative identity disorder. That's the more modern term for split personality, multiple personality. Schizophrenia is a form of psychosis. It's usually manifested by hallucinations. What's hallucinations? Seeing something that's not there. Okay? Seeing your mother when she's not there. Or delusions. What's a delusion? It's a fixed false belief. The person believes he or she's Napoleon. Okay? That would be a delusion. I represented mental patients for a number of years, and I dealt with many people with schizophrenia. At one point, I had 3 different clients who thought they were Jesus Christ, which was very interesting. I tried to keep them separate from one another. They were in the same hospital. But in any event, these are the kinds of manifestations you have with schizophrenia. Okay? Being out of touch with reality, hallucinations, delusions. It's a very serious disorder, but it's definitely treatable these days. We have good medications for them. And one thing I'm going to do over and over again when I talk about this, I'm going to talk about people with mental disability. I'm not going to talk about the mentally ill or the mentally disabled, because these are people first and foremost. It's very easy to slip in there, oh, that's a schizophrenic. These are people who happen to have a disorder called schizophrenia, just like you can have a person who happens to have angina, or a person who happens to have high blood pressure. Okay? It's a person with schizophrenia. And it's very important. I'm going to use the word crazy, and I don't mean to be pejorative when I use that word. I think, for better or for worse, the word crazy is a word that does capture what the legal system is interested in. Was the person crazy or not at the time of the offense? But I don't mean to be pejorative when I talk about that. And otherwise, I'll be talking about people with mental disability, people with serious mental disorder. I want to emphasize that up front. So Daniel McNaughton was a person with mental disability, a person who probably had schizophrenia, though since psychiatrists weren't really around in 1843, we don't know for sure. But he became convinced that the Tory party was out to get him. The Tory party being the dominant party in England at the time. This is, by the way, United Kingdom case. I should have made that clear. If that wasn't already clear from the fact that he has a Scottish name. And he decided that he needed to do something about it. He thought the Tory party was actually trying to assassinate him. And he had several bits of evidence. For instance, he had been walking down the street one day, and there was a hole on the wall behind him, and he became convinced that was created by a bullet that had been aimed at him by an agent of the Tory party. He went to the police to complain about this, and they just laughed at him. Said, right, Daniel, this is not going on. Get real. But Daniel thought it was going on, so finally he decided to take matters into his own hands. And he decided to find out when he might be able to kill Prime Minister Peel, who was the head of the Tory party at the time. He found out that the Tory party was going to have a parade with Prime Minister Peel in it. He stationed himself along the parade route and with a gun, and he tried to kill Prime Minister Peel. But just like John Hinckley, he was a bad shot. He missed Prime Minister Peel. However, unfortunately, he did kill the secretary of Prime Minister Peel. And he was charged with murder. But he had a very good defense attorney, and that defense attorney was able to convince the trial court and ultimately the House of Lords, which is the ultimate appellate court, was the ultimate appellate court in the United Kingdom, able to convince the House of Lords that he should be excused by reason of insanity. As a result of that case, we have the so-called McNaughton test, which I'll talk a lot more about next week, which is basically the idea that a person should be excused by reason of insanity if by reason of mental disease or defect the person could not understand that what they were doing was wrong. It's called the right from wrong test, understanding the right, being able to distinguish right from wrong. So that's one famous case. You all heard of the John Hinckley case. He's the person who tried to kill President Reagan. You may not remember why, at least according to the defense attorneys, he became enamored of Jodie Foster, the actress. And he became convinced, based on the movie Taxi Driver, if you remember that movie, he became convinced on the basis of that movie that if he could shoot or try to shoot the President of the United States, Jodie Foster, who was an actress in Taxi Driver, who was someone who got mixed up with a serial killer in the movie Taxi Driver, he became convinced that Jodie Foster would in fact fall in love with him, John Hinckley, or at least become attracted to him, pay attention to him. So he decided he needed to kill the president. He actually stalked Jimmy Carter. Didn't do anything, though. Eventually, he did try to kill President Reagan. As President Reagan was going into the Washington Hilton Hotel in front of literally hundreds of security agents and police officers, as well as many, many other people. He did hit Reagan, but as you know, didn't kill him. He also hit press agent John Brady. He was also acquitted by reason of insanity by a jury in the District of Columbia. So we'll come back to that case. Andrea Yates, I've mentioned her case a couple of times. Very sad case. Clearly suffered from schizophrenia. No doubt about it. Long history of schizophrenia. She drowned all 5 of her children after waiting for her mother to leave the house. Okay, so she planned it so that no one would be around when she did it. All 5 of her children, all under the, I can't remember now, I think the oldest one was 11, from 11 on down. And it's a very sad case. I know I was involved on a panel with the attorney who represented Andrea Yates, and he spoke first, and I spoke second, and his last slide was a picture of the 5 kids in their Halloween costumes. And I stood up and I couldn't talk for 2 minutes, just because it's such a sad case as to what she did. But she ended up, as you may remember, she ended up being convicted the first time by a Texas jury. But the conviction was reversed for reasons I'll probably talk about next week. On retrial, she was found not guilty by reason of insanity. Then there are a lot of cases where people think the person was found insane, but they weren't. This is based on polls. A lot of people think Jeffrey Dahmer was found insane. He was not. He did raise an insanity defense. Why? Because, as I think I mentioned last week, he would kill his victims, then perhaps have sex with them after they were dead, then cut them up, keep the body parts in the refrigerator, and occasionally snack on those body parts. That's extremely crazy, to use the professional word. And he claimed the insanity defense, but was not found insane. Son of Sam, Sam Berkowitz, serial killer. The claim by the defense was demonic possession. He believed he was possessed by the devil. He actually was a member of a satanic cult. He was convicted, not found insane. Charles Manson, you all remember him, Helter Skelter. He killed Sharon Tate and a number of other people. He was, by the way, clearly schizophrenic. He was a person suffering from schizophrenia. He claimed that he killed these people because he wanted to ignite a race war. What he did is he killed these white people and then planted evidence to make it look like African Americans had done the killing. And his idea was to get a race war going because he thought ultimately there would be a race war, might as well get things started early. That was his idea. He refused to raise an insanity defense, even though it was the only possible claim he had, because the evidence was very clear he was involved in these killings. His attorneys wanted to assert the insanity defense. He would not let them. Same thing with the Unabomber, Ted Kaczynski. You all remember that case? He mailed letter bombs to people and killed 3 of them through these letter bombs. What was his idea? Technology is going to destroy the world. If you remember his manifesto, his 35,000-word manifesto, one of the themes of that manifesto was technology is dangerous. Technology is ultimately going to destroy the world. I need to send out a strong message to prevent technology from destroying the world. What I will do is kill people who are closely associated with technology. All the 3 people that he killed, they sent the letter bombs to, were technologists, people who knew computers really well or some other type of technology. He, too, refused to let his attorneys raise the insanity defense. So none of these last 4 people were found not guilty by reason of insanity, even though there was evidence of mental disability in all 4 cases. That's just to sort of set the groundwork for the kinds of people that might be involved in the insanity defense. The last slide I want to go through today is what's happening with the insanity defense today. And then next week, we'll talk about specific insanity tests and some of the more notorious and controversial forms of insanity, okay, including, for instance, Vietnam vet syndrome, battered woman syndrome, neurological disorders, XYY chromosome syndrome. So a lot of very interesting topics we'll get to next week. But all I want to do right now in the remaining couple of minutes is talk about the status of the insanity defense. It's been controversial. 5 states have gotten rid of it. Almost every state that's kept it has reduced its scope. And I'll talk more about this next week. The insanity defense can be very broadly defined or it can be very narrowly defined. Almost every state has chosen a pretty narrow definition of insanity, or at the least switched the burden of proof from the prosecution to the defense. What does that mean? In the old days, the prosecution would have to disprove insanity beyond reasonable doubt. In other words, the burden was on the prosecution to prove the guy was not insane. Now, in most states, the defense has to prove insanity, So it's harder for the defense in those states where the burden has been shifted from the prosecution to the defense. A lot of people think the insanity defense is raised all the time. Why? Because when there is an insanity case, it gets reported in the press, and then you tend to get this image, oh, this is happening a lot. It's not raised very often at all, in about 0.5% of all cases. And also, it's very seldom successful. When it does get to a jury, it's only successful 1 out of 4 times. And in Tennessee, it has not been successful in any jury case since 1982. There's not been a single jury acquittal by reason of insanity since 1982. Does that mean there have been no acquittals by reason of insanity in Tennessee? No. A lot of insanity acquittals are the result of an agreement between the prosecution and the defense. This is why a lot of criminal cases are resolved. About 95% of all criminal cases are resolved through plea bargaining. It happens in insanity cases just like it happens in other cases. What happens is the defense attorney gets an expert, says this person's crazy, mentally ill. The prosecutor says, you're right. I agree. Let's find this person not guilty by reason of insanity. Let's not go through a trial. We'll put this person in a mental hospital. Well, by the way, they'll probably stay for a very long time, because this is the last thing I want to say. The notion is often that if you're found insane, you walk, right? You're found not guilty by reason of insanity, so you let go. Or you're only kept in a mental hospital a very short period of time. That's wrong. The research shows that in virtually every state, if a person's found insane, they spend at least as long in a mental hospital as they would have spent in prison had they been convicted of the crime. And prosecutors know that. So if what they're worried about is public safety, and the defense attorney has a good case of mental illness, the prosecutor might say, yeah, go ahead. Plead him not guilty by reason of insanity. They'll end up in a forensic unit. There's one right here outside of town where they keep people found not guilty by reason of insanity. And that person will probably be in that hospital for at least as long as he would have been had he been sentenced, at least in non-capital cases. So that can happen quite frequently. So that gives you some background on the insanity defense. What we'll do next week, just to titillate you, is we'll talk about whether it makes sense to have the insanity defense, and then, as I said, some of the cases on the edge of the insanity verdict that raise some very controversial and interesting issues. Yeah, last question, then we ought to stop. Mm-hmm. So, yeah, that's what we will talk about next week, is can we distinguish between mad and bad, evil and not guilty for purpose of insanity. That's basically the topic for next week. So thanks very much. We'll see you next week.